Welcome back. We're now going to go ahead and review Section 4 in Chapter 6, which deals with defenses to criminal liability. Now, there are certain defenses. Let's say you did commit a crime, but for some reason, some of that commission of the crime may be justified. The book goes over several examples of when a criminal action may be justified, and thus you can avoid liability, meaning you can avoid going to jail. One of the basic ones, and probably one of the ones that you've heard of the most, is self-defense. Committing a crime in the act of self-defense usually grants you avoiding of liability for the action. What do I mean by that? If somebody's attacking you and trying to stab you, it's okay to stop that person from trying to stab you. If that includes hitting them, using non-deadly force, or even at times deadly force to stop a person from attacking you. That is perfectly allowable under the doctrine of self-defense. That's its basic element. The book goes into different items, especially the idea of when you can use deadly force, but in our general understanding, if you're protecting your own life, somebody's trying to kill you, it's usually allowable for you to defend yourself. The book talks about necessity. Necessity, it comes up in a particular example. The book has a great one. It's illegal in the state of Florida for a person who's been convicted of a felony, somebody, let's say, for example, that burnt down a house and went to jail for more than a year. When they get out of jail, it's usually illegal for a convicted felon to carry a gun. Now, what would happen if the convicted felon was at a grocery store buying some groceries, and then somebody came into the store with a gun and tried to rob the store? The convicted felon then tries to help, and he grabs the gun and waits until the police arrive. Well, the convicted felon has a gun in his hand, but it falls most likely under necessity. Since he was trying to help stop the crime, it was a necessary action for him to hold the gun. The insanity defense. This is probably one you've also heard of. Insanity defense in the real world is actually a lot harder to get. You have to be actually insane. We'll go over the various elements because insanity is a fun defense to learn about. But the idea is, if you have no idea what you did when you were committing a crime, if you were out of your mind, essentially, then usually you can avoid criminal liability. You declare the defense of insanity. Now, there's a term, mistake. But remember, ignorance of the law is not a defense to breaking the law. But if you had no idea that you were actually doing something illegal, when they talk about mistake of fact is what that is referring to. The book has a great example. You accidentally pick up somebody else's briefcase believing that it's your briefcase. You walk away with it. Turns out cops show up, ask you why you stole that person's briefcase. Usually you can claim mistake of fact. You didn't know that it wasn't your briefcase. You thought it was. That is much different than you being unaware that stealing somebody's briefcase is against the law. That's a mistake of law, but a mistake of fact involves the actual factual elements inside of the act you committed. Duress. Duress is another defense. If somebody holds a gun to your head, they have a lot of movies where they strap bombs to people and tell them to go rob a bank. That's a perfect element of duress. If somebody's holding a gun to your head or asking you to commit a crime or they will hurt you, usually you can claim duress. Entrapment. If the police lie to you, this is extremely hard. A lot of police actions involve lying to criminals to try to get them to do something illegal or to admit something that they did. But entrapment goes to the next level, and it's a little bit complex, so we'll have to talk about it in class. But make sure to read it in the chapter here about entrapment. Statute of limitations. A lot of crimes have what we call statute of limitations, meaning that if enough period of time passes, you can no longer be held liable for the action. Immunity. Immunity is a big one. You guys will probably be most familiar with it, dealing with the international elements of consulate officers being immune. You have foreign immunity, foreign ambassador immunity to certain actions. And so that's when it comes out. We also have a thing called spousal immunity, where your spouse cannot be forced to testify against you, which is pretty interesting. Real quick, I want to skip over the Miranda Rules section and just talk about the criminal process itself. So I'm going to page 157. The criminal process, basically when you're going through the criminal process, let's say, for example, You find yourself breaking into a house trying to steal a TV. Well, as you're leaving with the TV, the police show up. What happens at that instance is you are placed what's called under arrest. The officers stop you, tell you to put down the TV. They read you your Miranda rights, which we skipped over, but we'll go over in class. They read you your Miranda rights and they place you under arrest. The police have stopped you and put handcuffs on you. They take you to jail. They go ahead and book you for your crime, take your fingerprints, etc., etc. They hold you in jail and you wait. Because the next phase is what's called the indictment or the filing of information. This is where the prosecutor, who works for the state attorney's office, in our state, that would be the state of Florida, they go ahead and file an indictment or information, basically alleging what you did wrong based on what the police officers said they saw you do. So they say, listen, we saw you break into the house, so you are guilty of burglary. If you go back to burglary, burglary is the commission of breaking and entering a home with the knowledge or the intent of committing a felony therein. They file the indictment or information with the judge. The next phase is trial, where you go before a court. Usually what happens, you'll have a jury trial. 12 individuals will go ahead and debate over your guilt or innocence. The reality of the situation is most criminal actions don't go to trial. I think it's somewhere around 99% of criminal actions actually get pled out. What do I mean by pled out? Is that the criminals agreed to go ahead and enter a plea for a lesser amount of time in jail or probation. Now, it's an interesting element as to why this occurs. A lot of times prosecutors will do something called stacking of criminal charges, where they charge you with multiple offenses, with the idea is you'll agree to at least one of them to avoid going to jail for a very long time, and the idea of going to jail for a very short time. I posted next an article on cybercrime because I think it's good. The book is a little bit older version, so I wanted a more up-to-date element on cybercrime. So after this video, you're going to be reading an article on current elements of cybercrime. So thank you very much. We'll have one more video after the article, and then that will be our lecture for the week.